Hello everyone, welcome back. If you're new here, you're very much welcome. In today's video, I'm going to do an analysis of the Madlanga Commission of Inquiry Friday's hearing. On Friday, it was very strange. The Friday Madlanga Commission of Inquiry felt really strange, and I was disappointed about what happened on Friday. So on Friday, we had a legal team that represented an implicated person, Suliman Carrim, who is known as the businessman in Northwest Province in South Africa. He's also a member of the African National Congress Party, the main political party in South Africa. And then he went to this, he's meant to come in and testify. However, they requested to speak to the commissioners on Friday because they wanted him to have his testimony in camera. Yeah. The reason for it is they claim that he has received some threats to his businesses, threats to his family, threats to personal life, and yada yada. Now, I'm very skeptical about him, and I'll tell you why I'm skeptical. First, he was subpoenaed to testify. Then, instead of coming to testify, he went to the High Court requesting that the High Court must reverse the subpoena. He shouldn't be subpoenaed to testify. Of course, the High Court rejected that nonsense. All right, who does he think he is not to testify? This type of people that are involved with the ANC, their behavior, who does he think he is? Who people testified, people whose life was so much risk, they testify and provided their testimony to help the commission. All right, the commission investigation, the allegation that were made by Lieutenant General Madlanga about the infiltration of the criminals into the law enforcement and all structure and political interference. So he thought, his special one, he didn't want to be subpoenaed. And then he went to the High Court. The High Court rejected that. Then he came on the 6th of February. He's meant to testify on the 6th of February. On the 6th of February, he requested that to be postponed. That was granted, which I think, in my view, they should have declined it. But anyway, they gave it a generous extension from the 6th of February till the 9th. He's meant to testify tomorrow, the 9th of March. From the 6th of February to the 9th. That's how long his extension for his testimony was. However, it looks like, and then in the 9th, on the 6th, when the commissioner told him that he needed to actually file his affidavit testimony and on a specific day, I think the specific day they gave him was the 27th of February. That is, you must, on 27th of February, you must file your affidavit on that day. Okay, do you think he did it? No, he didn't. What he did instead, he created his own rules to say, I'm not doing that. I am going to write to the commission and request an in-camera. If they don't respond to my request for in-camera, I am not giving them my testimony. Let's just hear how his legal team trying to defend this nonsense. Okay, let's listen, guys.
Thank you, Chair, and for the indulgence of going ahead of you. My learned friend is correct. This is an application that my client's main evidence be given in camera. My concern at the moment is that even though the directive says that it will be given in an open session at the college, as we are here today, my concern is that if the in-camera application is argued in front of all and sundry, and I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in the way that we are physically here, but that it would still be determined in camera pending whatever outcome is to be made, as opposed to how we had asked for the reasons canvassed in the in-camera application, that it be done virtually or at a different venue and so on. And so I just have to register my concern, with all due respect, that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or live television proceeding that goes out. And may I just say this, I can understand that if the Commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in, where the very request for that proceeding itself is to be in camera. Otherwise, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premhid. Mr. Premhid, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Carrim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered nugatory. I just don't follow it. I
followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the concept of that.
Yeah, I think the argument was very weak. When the argument is weak, you can hear a lot of these lawyers try to use the ethics when there's no legal framework to argue their point. And it's what we witnessed on Friday. But however, it went worse because the lawyers, they weren't listening. This guy, Premhid, wasn't listening, wasn't hearing what the commission had to say and then understand that and then move on. No, it's almost like, he had written an essay and wanted to read it out, that essay, regardless of what the other person is commenting on. No active listening skills whatsoever. It was loud, it was cretaceous, it was shocking behavior. And this is actually a hearing, inquisitive hearing. It's not a court battle. No, it wasn't a court battle to have that kind of energy, that kind of demeaning. I mean, he came in there to try and attempt to really to capture the perception, the public perception of the actual inquiry itself, because he brought a lot of stuff that he may be prejudiced. Why would a commission prejudice someone like him? For what reason? Huh? Because really, what they needed to do was to prove the evidence of threats, to link the threats to the testimony, the testimony itself, the affidavit that it was asked to file, but it turns out he did not do it. Risk reduction from secrecy, all of that. They need to argue that. That's what they needed to do.
Effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Carrim wants the public to be under the impression that he will not be testifying, or exactly
no, that's
what then. What then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was conducted in camera in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight to the people outside of this room that the in-camera application was made. If it was granted, then the public knows that Mr. Carrim ought to have testified on the 9th and the 10th. That might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these things were in camera, on the 9th and 10th, if the commission me and grants the in-camera substance, then whoever is threatening Mr. Carrim and the public at large would have to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be, insofar as Mr. Carrim's appearance at the commission is concerned. That would not release Mr. Carrim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected, offer him an modicum of protection where he says, I'm being surveilled and I'm threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Carrim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to or at least part of it, boils down to what I said, which is that he does not want the public to know that he will testify.
That's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said says exactly what I say.
No,
Of the various permutations you gave, part of it says exactly what I say.
I accept that, but we
Yes.
also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes, which the public at large would not know about. So it's not as though Mr. Carrim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Carrim accepts he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me there, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
That his behavior was gratuitous. Gratuitous behavior with no known cause why. He just attempted to capture the Gupta 2.0. They're everywhere. Guptas are everywhere in South Africa. You haven't gotten rid of them. They're still there. I mean, the audacity. The audacity.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this a preliminary concern now,
No,
Chair?
but no.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you, Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Carrim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising
Yes.
in the context of
Yes.
that submission.
I accept that, yes.
How will the commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Carrim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And
content
I'm
of
not
the
suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. As you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to... The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah, the Gupta moment, the phone call from the minister in the middle of Commission of Inquiry hearing, a publicized Commission of Inquiry hearing. No one asked him who was giving you a phone call, neither the commissioner, there was no one who asked about that, who was calling him. But he told us the Minister of Finance just called him in the middle of a hearing. The hallmark of the Gupta, the capture of the state, the era, capture era politics. Institutions were accused of biases. Exactly what he's attempting to say, that the Madlanga Commission prejudiced his client without giving any substantiating facts or evidence, nothing. So they demanded the rulings on their own timetable. They treated non-compliance consequence, because if you're not complying with the commission's ruling, you're going to have consequences. Oh, that one is persecution, because the commission, when they reminded Suliman Carrim that he's in contempt of the commission by failing to file those documents that he was requested to file on the specific date, the lawyer now claimed, no, his client has been prejudiced, been persecuted. Alleged bad faith by commission staff, and alleging there could not be any confidentiality without substantiating any of those allegations. So it weakens Karim's side so badly, because it shows the complaint may be less about actual unfairness, but more about the resentment, of being subjected to the same rules as everyone else. The resentment is that Suliman Carrim is subject to the same rules as everyone, including ministers, former minister Msenzo Mchunu. Everyone followed the same rules, including IPIT investigators who had faced threats, who have actually had threats against their family members that were actual threats that succeeded against the family members. They came and gave the testimony. Now we're going to have the Gupta's brothers coming telling us, no, we commissioner must have a special seating for them. Must put them somewhere different, and everything about them must be special from the rest of everyone else. This is a person who's facing serious allegation, who is in the center of these big five cartels. He's probably in one of those 2-3 ladders skeleton that haven't filled out. Who knows? But he is in them. He's been coordinating with all of them. We saw the WhatsApp messages. So no, this person who's facing serious allegations, we now have to change the rule, have to bend the rules a little bit for him, because the Guptas have arrived, they're going to tear the place down. My goodness, that's my analysis of what happened on Friday. This is how a summary of this nonsense, because it's very long, guys, because I don't want to go through this, because I was so annoyed on Friday. I mean, so annoyed that I think I posted a couple of posts on my TikTok account about this. I mean, shocking. Anyway, let's just listen about how, Madlanga handled this. I mean, just the retired Justice Madlanga. I give it to him. He was able to compose himself. But Baloyi wasn't having it. Commissioner Baloyi wasn't having it. I could see it in her face that she was not having it. And, I don't blame her. I wasn't having it too. I was not having it. Yeah.
Thank you. Maybe on just that last point, to start there, that other witnesses, including Mr. X, have testified in camera and arrangements were made to protect their evidence. That's not applicable here because all the decisions about witnesses testifying in camera is based on the testimony that they are going to give. You bring a completely different application at this stage.
Yes.
You say the application itself to be heard in camera should be in camera. So yours is not, I mean, those other cases don't apply to you here, one. But you, in your engagement with the chair, you speak to, you want to be heard in camera. There's actually two legs to your application. You want this very application to be in camera because you don't want it to be known why the reasons that he's seeking to be heard in camera. Well, they are out there now.
It's too late now. Yes, absolutely.
And as an aside, I would have thought ordinarily a person would want it to be publicized that the concerns that your client has, that there are people who are making threats against me, they would want the light to be shown on those who are making the threats on them so that they know the world is watching. I would have thought that's what your client would want to happen. But more importantly for me, you have two parts to this. The second part is you want the papers, including this application. So we are not yet in the merits. This very application that you are before us about and that you are arguing about, you wanted the papers to be shared only amongst a defined number of people in the commission. You say the chairperson and commissioners, the evidence leader designated to lead, Mr. Carrim, the commission's appointed legal team, the secretary, Mr. Carrim, Mr. Carrim's appointed legal team, and the commission's official transcriber. You haven't said why you want to restrict. You want the commission to restrict who has access to these papers. And I've tried to read your papers. I don't see a case made for it, including for this leg of the application. I mean, it seems like your client is wanting something that certainly I've never encountered anything like this, and he doesn't lay a basis why only these seven or people in these seven categories should have access even to this, even before you get to his statement on the merits or the application to be heard in camera. Just even this preliminary issue. Can you just explain what's going on? I really don't understand this application. And on what legal basis does your client think he's entitled to have to prescribe, as he's doing, about who should have access to his papers, one? Two, the legal basis for him to seek to be heard in camera, his application to be heard in camera. I've never, ever encountered that, and I don't see a legal basis for it set out in your submissions, but also the factual allegations, if there are any factual allegations here. I don't understand this application, Mr. Premhid.
May I respond? Thank you, Chair. Commissioner Balo, I thank you. May I with the first question about the prescribing of the access. That is rooted in the understanding of the applicant of Rules 4.2 and 4.3 read with Rule 11, which on our reading, 4.2 says, in an appropriate case, the chairperson may make an order that a hearing be held in camera or via electronic means. In such a case, the chairperson shall specify in the order those persons who shall be permitted to attend the hearing in camera or by some other means. Then with 4.3, at the request of the witness whose evidence is to be heard in camera or meru motu, the chairperson must order that nobody may, directly or indirectly, disclose the identity of the witness who is to give the evidence in camera, and then read with Rule 11, which is the so-called catch-all rule, which gives the chairperson the procedural right to determine issues not otherwise prescribed in the rules.
Yes, what I'm trying to understand is this defined list. I understand the rule. I know what the rule says and the powers that it gives the chairperson. What I want to understand is when your client says only the evidence leader dealing with the matter should have access to this application that we are concerned with right now, on what basis does he assert that kind of
Yes.
of request?
Yes.
We have a whole team of evidence leaders.
Yes.
We have investigators.
Yes.
Right? You know that.
Yes.
There is no explanation
Yes.
why those should not
Yes.
have access to this application.
Yes.
And I can put to you that, at least in my reading of your application, there's nothing confidential
Yes.
about it. He's not, your client is not disclosing any confidential matter. The best he does is to suggest that the threats are confidential. That's because that's the only basis on which he's seeking for this first leg to be heard in camera. And all he speaks to is the threats. So he's asking for the threats to be kept confidential. Why can that not be shared with the rest of the staff of the commission? Why shouldn't the staff threats that he's relying upon?
Let me immediately accept that on the strength of the affidavits as prepared and submitted in front of the Commission, there is no direct engagement with why the list curtailed in Schedule A is presented in the way it is presented. I accept that, and I'm not going to dispute that, because that would be a hopeless cause. But I hope that, Commissioner Baloy, you can see that there is a relationship in the exercise that is being done in Schedule A with what is set out in the rules that I've just read to you, in the sense that where in an appropriate case there is an in-camera consideration, the chairperson can make an appropriate directive to limit access as to who can or cannot have access to those proceedings and the papers. So
yes, I'm not having that debate with you.
No,
I know that's what the rules say,
Exactly.
and we have used the rules.
Exactly.
What I'm struggling with, or what I don't see,
Yes.
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
Yes.
set out in the
And
papers.
that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content the application is threefold. Number one, Mr. Carrim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Carrim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Carrim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Carrim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Carrim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the commission that they may not distribute. Or in fact, he doesn't trust the commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes to my question?
It is a yes, but okay. I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes, in the sense that, you know, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the Commission to the public?
Does it involve breaches of confidentiality?
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago, on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Premhid, what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the Commission, it does not include a complaint that the Commission has disclosed what he has to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified. That's not what you're complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
but Mr. Carrim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premhid.
With all due respect,
Mr. Carrim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD, it's not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
intervened twice, my colleague was still asking you. Yes, please go on.
May I respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says.
Yes,
I apologize for that. But Chair, it's very important, because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the Commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the Chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the Commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the Secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the Commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the Commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me, that it's not for Mr. Carrim to determine, but we need some clarity from the Commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the Commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here, because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the Commission are unconscionable, and with all due respect I speak subject to the chair putting me back in order if I'm out of order, is that the Commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Carrim acting of his own accord. Mr. Carrim at every stage saying to the Commission, place this in front of the Commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats. But there's a factual context that's important to bear in mind as well, and that is that Mr. Carrim sought the assistance of the Commission to let him know what to do by the 27th.
You say you hear what I say about what you referred to as threats, and yet you proceeded to say what the Commission did is unconscionable. I take strong exception to
I'll withdraw that statement, Chair.
kind of language.
I'll withdraw that statement.
Thank you. Thank you. What you've said raises two issues. What
Yes,
you
Chair,
have said, what you have submitted raises two issues. The first one is you asked the Commission to keep all documents, affidavits and all relating to this matter confidential. The first issue is, I have no idea why Mr. Carrim would not have wanted to file his statement if, in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline, yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
So the argument of his legal team is so weak. They argue that Suliman Carrim is prejudiced because he was threatened that he is in contempt of the Commission by failing to file his affidavit on the 27th of February 2026. That is prejudice. By creating his own rules that he wanted an in-camera sitting midway through, and then he decided not to file while the actual instruction directive was you need to file by this date. Because then he received an email to say you are now in contempt. That is prejudice. By facing the consequences of his action, he's claiming that he's been persecuted. Yeah. The Guptas haven't left South Africa. They are everywhere. The Guptas, they're everywhere. Okay? Thank you guys for listening. Until next time.